practice law in Rhode Island. Please don't construe anything I say as an opinion of law. It's not intended that way.
We don't.
Okay. You're not going to believe this, Mr. Duhamel. I'm going to break with Mr. Ben Weber. I disagree. I think it was a master stroke for you to put the final nail in Bill Conley's coffin over here, because you asked him to write a memo on how rights of ways are created, right? And his present position is they can't be created by resolutions, right?
One second, I just can't understand if you could speak a little closer to the microphone, I could probably hear.
Okay.
Yes.
I want to thank you for putting the final nail in Bill Conley's coffin over here, because now he's going to prepare a memo on how rights of ways are created. And he's going to have to explain why his position in the motion for summary judgment is resolutions can never be used to create rights of ways. Resolutions like the one on October 6th, 2008, that created the Fort Road right of way. What's critical here is that in the title of that, it says it's creating a right of way in perpetuity, something permanent, forever. And then in the resolved clause at the bottom, it again repeats that. That resolution is trying to make a permanent change. It's adopting a right of way permanently. Now, earlier tonight, I provided some documentation that I picked up at the Judicial Records Center in Pawcatuck, and I explained that it had to do with a lawsuit in 1961 around the rights of ways Atlantic Avenue, and that the state of Rhode Island asserted resolution passed by the Westerly Town Council on August 5th, 1940, adopting 20 rights of ways. They presented that against the plaintiffs. The plaintiffs lost. The judge found in favor of the state that those rights of ways were legitimate. They were created by a resolution in the language of the Rights of Way Commission. They called it a resolution. Of course it is. We know what it is anyway, but they used that word. And when you look at that resolution where they adopted it, it specifically says that the town of Westerly should clear those rights of ways, mark them, and maintain them properly indefinitely. That's a resolution implementing a permanent change. Now, when Mr. Conley writes his opinion, Mr. Conley, I would ask that you, I'm sorry, I can't talk to you. I would ask that you please make sure that Bill Conley addresses the Rhode Island Supreme Court precedent of O'Connell v. Rime, R-I-M-E. That's 710 Atlantic 2nd, 674, 679, Rhode Island Supreme Court, 1998. Because although I'm not licensed in Rhode Island, here's what this language says about whether or not resolutions are ordinances, the like. It says, generally, whether what is done by a municipal legislative body is an ordinance or a resolution depends not on what the action is, not what it's called, but on the reality. Where a resolution is in substance and effect an ordinance, my computer stopped. Sorry. Where a resolution is in substance and effect an ordinance or a permanent regulation, the name given to it is immaterial. I believe Mr. Conley is going to have to admit that under the precedent of O'Connell v. Rime, the 2008 resolution is actually the functional equivalent of an ordinance. It's more properly termed the 2008 ordinance. Similarly, because they use the words in perpetuity, similarly, on August 5th, 1940, when the Westerly Town Council adopted the 20 rights of ways, as I mentioned earlier, again, they said that they should be marked and maintained properly indefinitely. You make sure to explain whether all of those rights of ways are legitimate under the precedent of O'Connell v. Rhine. Now, I would ask one more thing. So thank you. Thank you for asking. I think it really will help clarify things. You might want to ask him also why his strategy is to give up on the motion for summary judgment, partial motion for summary judgment, when the Watch Hill Fire District is asking a court to take care of only town affirmative defense number 11. Mr. Conley pulled out all the stops when he prepared his answer on behalf of the town. He asserted 16 independent defenses against this lawsuit. Here's a copy of the Watch Hill Fire District motion for partial summary judgment. They're gunning for number 11. Anyone who can count should appreciate that there's still 1 through 10 and 12 through 16 left. I happen to bring a copy of Mr. Conley's answer so you can bring it into executive session and ask him about this stuff. They start on page 8, they scroll over to page 9. Seems to me, even if you lose on the motion for summary judgment in its entirety, you still have 15 different defenses left. Well, this has been productive. I thank you all for your time.
Thank you.